You have been doing the research, you found that surname in census records, maybe a village name, maybe a ship manifest, and then someone told you, or maybe you read it somewhere, if your family left Lithuania before 1918, you might not be eligible, and that stopped you. Today I want to explain exactly why that date matters, what it means legally, and what it means for you specifically. My name is Dainius Ambrazaitis. I'm an advocate and co-founder at Injure law firm in Lithuania. For over 15 years, we have handled more than 4,000 Lithuanian citizenship cases for clients across the United States, the United Kingdom, South Africa, Israel, Canada, and beyond. What I want to do today is answer one of the most common questions we receive. My ancestor left before 1918. Does that automatically mean I'm not eligible? Let's clarify this properly. Why does 1918 matter? Before February 16 of 1918, the Republic of Lithuania did not exist as a sovereign state. That means Lithuanian citizenship as a legal institution did not exist either. People born in the territory of present-day Lithuania before that date were subjects of another state, most commonly the Russian Empire, and this is the legal consequence that matters most. If your ancestor emigrated before 1918, there was no Lithuanian citizenship for them to hold, keep, or pass on. It is not about losing citizenship, it's about the fact that it did not yet exist. And that leads me to another very common question regarding the later naturalization date in another country and whether that changes anything. For example, your great-grandfather left Lithuania in 1908, but he didn't become a citizen of America until 1932. The question that often arises is, doesn't that mean that he held Lithuanian citizenship in between? The naturalization date in another country is not relevant if your ancestor left in 1908. The gap between these two dates was not spent holding Lithuanian citizenship because in 1908, Lithuanian citizenship did not exist. And I understand why that conclusion feels frustrating. The family connection is real, the Lithuanian heritage is real. Why should a date, one specific year, change everything? However, it is a historical fact about when Lithuania as a sovereign state came into existence, and that is February 16, 1918. One more thing before we go further, and I will keep this brief. Some people arrive at the question of eligibility for Lithuanian citizenship by descent through a DNA test. They see Lithuanian or Baltic ancestry in the results and it sparks an idea. That is perfectly good reason to start this journey. DNA can be the inspiration, but the legal answer requires something different. Documented facts about a specific ancestor who held Lithuanian citizenship. That is where we look together. So what does qualify? First, eligibility requires a direct Lithuanian ancestor, parent, grandparent, or great-grandparent. Citizenship passes only through a direct line, not through cousins, siblings, or relatives who stayed in Lithuania. The lineage must be traceable through 3 generations and through documentary evidence. Second, that ancestor must have held Lithuanian citizenship and that they must have emigrated between 1918 and 1990. Third, they must have been born in Lithuania before June 15, 1940, when Lithuania was still an independent state. Why June 15, 1940 matters? Because that is when Lithuania was occupied by the Soviet Union. Lithuania's statehood continued legally, but eligibility after 1940 depends on one crucial detail. If your ancestor was born before June 15, 1940, they were born a citizen of Lithuania. If they were born after that date, in the Soviet Lithuania, they were born a citizen of USSR, and that line does not create eligibility. Let me put some of these legal points into real situations. A client came to us from the United States. His great-grandfather left Kaunas in 1906. The family knew exactly when. They had the ship record. His great-grandfather became an American citizen in 1932. The family believed that because naturalization happened so late, Lithuanian citizenship must have been preserved in the meantime. Legally, that reasoning does not hold. His ancestor left in 1906, 12 years before Lithuanian citizenship legally existed. There was nothing to preserve. The naturalization date in 1932 is irrelevant to the question of Lithuanian citizenship. Thus, the ancestral line was not eligible for the Lithuanian citizenship by descent. A different client from the United States. Her grandmother was born in Cholet in 1910 and emigrated in 1935. She became a US citizen in 1950s. Her grandmother held Lithuanian citizenship before leaving in 1935. The client is now a Lithuanian citizen. She did not lose her American passport. One more example of a client from Canada. Her grandmother emigrated to Canada in 1979 when Lithuania was under Soviet occupation. Since she was born in 1939 and emigrated to a non-Soviet country, her granddaughter, our client, was eligible to reinstate her Lithuanian citizenship by descent. If you just heard something in this video that makes you uncertain, that is not a bad outcome. Uncertainty based on real information is far more useful than confidence based on assumption. Here is what I want you to take away from this video. First, the single most important fact in your family history is the emigration date. If your ancestor left Lithuania after 1918, that line is worth examining carefully. If they left before 1918, eligibility through that specific line is almost certainly not possible under standard procedures because Lithuanian citizenship did not exist yet. This is not a judgment, it is historical fact about when state came into being. Second, the second day that matters is June 15, 1940, when Lithuania was occupied by the Soviet Union. If your ancestors emigrated after that date, the question becomes, were they or their parents or grandparents born in Lithuania before 1940 occupation? If yes, their citizenship was Lithuanian, and it is a case worth examining more closely. If no one in the family were living in Lithuania prior to 1940 and they only moved to Lithuania after 1940, then their descendants would not be entitled to Lithuanian citizenship by descent. Third, the connection must be through a direct line. Parent, grandparent, great-grandparent. A cousin, a sibling, an aunt, an uncle who was Lithuanian does not create eligibility, even if they were citizens. And if you have come to this question through a DNA test, that is perfectly good reason to start the conversation. DNA can be an inspiration, however, only the legal work confirms the answer. Fourth, you do not need to have all the answers before you reach out. You do not need a folder of documents, a complete family tree, or certainty. All you need is a basic sense of your family history, the full name of your Lithuanian ancestor, when they left. That is enough to begin a proper legal assessment. There are two ways you can take the next step. The first is our free eligibility assessment quiz. The link is in the description below. It will walk you through the key questions about your family's history and give you an initial picture of where you stand in a few seconds at no cost. The second option is a free initial consultation with me directly, also available through the link in the description. If your situation is more complex or if you are ready to get a proper legal assessment, that is the right place to start. Do not make decisions based on assumptions. Make them based on legal clarity. Thank you for watching.